You've heard the story and read the comments by now regarding singer Miley Cyrus being sued for copyright infringement by Tempo Music Investments. This isn't the first time the songstress has come under fire for this kind of infraction, and it certainly isn't the first time the music industry has navigated these scuffles. With a closer look at the history of this phenomenon is a patent professor, John Rizvi. He joins me now. Thank you for being here. We appreciate it.
Yeah, it's always a pleasure. Thank you.
This is the fourth copyright infringement lawsuit for the singer. Not all have been about music, but it begs the question, is there an end to how many different melodies that can be made? And obviously, we're sampling samples at this point. Can that be the norm?
Yeah, well, you bring up a great point. I mean, kind of to put things in perspective, in 1952, there were 144 songs released in the entire year. Today, we're getting 60,000 songs a day, new songs released just on Spotify. So there's bound to be a lot of overlap. It's just the sheer volume of new artists that are producing music. And remember, there's only 12 musical notes. That hasn't changed from 1952. So you have 12 musical notes. There's a limit to how different they're going to sound. So yes, they're but just because two songs sound similar doesn't mean that under the legal standard that there's copyright infringement.
For me, being a music fan, the first one that pops into my mind, of course, is Vanilla Ice and Queen. Under Pressure and Ice Ice Baby being very similar, and his argument just being that little there being the difference. Are these legitimate arguments by these musicians? Are those things that are very defendable in court to say, I did my own thing, we have these 12 notes, and I just did what I could with them?
Yeah, so I mean, the Vanilla Ice case has almost become iconic, right? It's even been a subject of a lot of late night skits or whatever. Like there's a lot more meat to that copyright infringement suit, certainly, than we have here. But yes, the volume's gone up, but they're not always successful. I mean, Ed Sheeran successfully defended copyright infringement suits recently just because something sounds the same and there's going to be a bit of overlap. A lot of time the judge is going to let the case go to a jury if the judge believes that there's an issue of fact for a jury to decide. However, this may be a case where a judge may decide that no reasonable jury could find a copyright infringement and not even let it get to a jury. But that I've been surprised before, so we'll have to wait and see what happens. Unfortunately, we don't have a lot of precedent because a lot of these lawsuits are just settled out of court before there's a jury decision, because unfortunately the artists that are sued just don't want to take the chance that a jury of 12, and they're ordinary listeners. That's the test. So it's the ordinary listener, not the music aficionado, not the expert that knows chords and progression and tempo and melody, like all of those things. Just what does the ordinary user hear, and do they see a striking similarity that rises to the level of copyright infringement?
In your opinion, do listeners usually care about that, or do they find, I find it unique. I find it fun when a song pays homage to a different song in certain ways.
Yeah, so, like being inspired by another song, like that's okay. And certainly, Miley Cyrus, like her song is a bit of a clapback, right? Because, and that is fun for listeners, but, that's not the standard. It's just being fun for listeners does not make it okay. But just because something is a clapback or inspired by another song doesn't make it copyright infringement either. Yeah. The two things have to be shown. The first is going to be a piece of cake, and that is access to the copyrighted work. That's more of an issue where, maybe an artist doesn't release their song, but they file for a copyright, and they need to show that the alleged infringer knew about it. That's not the case here. Like, I mean, who hasn't heard of Bruno Mars' song? So access is not the issue. Now, substantial similarity is the issue. And in these copyright infringement cases, even though it's the ordinary listener, these trials are full of experts like audiologists, and you have music experts that talk about progression, and they get extremely technical. And that's where, some of the musicians say that it's really becomes a battle of who has the better experts and who has the better lawyers, because in the end, it's not the ordinary listener making these decisions unaided. Like they've given all this expert testimony, and that kind of biases their decisions. So it's tough. That's why a lot of these cases settle, and it seems to be almost a money grab of sorts because of the number of lawsuits that are being filed.
Will there be a point, in your opinion, where these lawsuits just don't happen? Especially when you start looking at social media, TikTok, things like that. Like, I would think it would be really hard to prove that, A, I wrote this song before you, or that I recorded it before you, or I came up with this collection of tunes together. Like, it seems like those things would get harder to defend with the overpopulation of music.
Yeah, well, it is. I mean, certainly the more, as I said, the sheer number of new songs that are being released. But I think the only way to really curtail these lawsuits is to have some legislation that makes like some kind of initial finding before the case actually gets to go to a judge or jury, like something really rudimentary to kind of stop the flood of cases that are meant, in some cases, just to extract money from a well-known musician.
Is that hard to do, though?
To go back to your initial point, how you started the interview, is like tempo music is not Bruno Mars. So Bruno Mars hasn't even joined the lawsuit. And sometimes these investment companies that are buying rights to the copyright, they're looked upon disfavorably as almost intellectual property trolls, so to speak, because they didn't create anything. They're not suing for some violation of their own. They simply purchased rights from one of the co-writers of the song and are asserting those rights. Under the law, that doesn't make a difference. But I can't believe that it doesn't make a difference to somebody on the jury. It would be a lot different when you have, the actual plaintiff is the original musician bringing the lawsuit. It's a lot easier to feel for a jury to sympathize and see that his song's been stolen and his rights have been taken than it is, even though the law makes no distinction because they have the legal right to do it. But here you have an investment company that's asserting rights to infringement. That does make a difference.
Fun. And again, as you mentioned, obviously a huge difference when you're talking Bruno Mars. I'm sure he's not too worried about people thinking that his song, I Should Have Bought You Flowers, is the same as Flowers by Miley Cyrus and that sort of thing. So just an interesting case all around. And you and I could talk forever about this. I find it so interesting. You do a great job. Great insight there from patent professor John Rizvi. If you are interested in John's work, you can head over to allindia.tv for more information. We thank you again so much, and come chat with us again, okay?
Yeah, always a pleasure. Thank you.